Recording in progress. Honorable members, good morning. I'm
Good morning,
also
Chair.
Good morning, Chair.
Morning,
sound
sir.
check this way, members. Good morning. Okay, I just want to make sure I'm visible. I haven't cut myself on the screen. Okay. Good morning, honorable members, and thank you very much for joining. So let's try and keep the meeting as efficient as possible in terms of time, because I imagine members have to travel. I'm one of those, or you are traveling already. We call this meeting to discuss correspondence we have received from the former chief executive of the Road Accident Fund. There's been an exchange of correspondence between us. That correspondence was sent to the members yesterday, and the short version of it is the following. Since members have that correspondence, so I won't do chapter and verse of it. Is that like everyone else, the former chief executive was invited to appear before the committee, was given dates towards the end of the inquiry. And the reason being that that is when we are intending to have all the decision makers, board members, executives, current and former executives. That's also when we will have the minister and deputy minister appearing. It's also for efficiency's sake, so that we don't call them repeatedly. So to the extent that anyone makes allegations against any executive or a member of the board, or says something that we believe that they need to have responded to or done, they have the benefit of hearing that and then preparing accordingly to respond to such allegations. So that is the purpose of inviting them towards the end. Initially, we did not get a response from the former chief executive. I implored the parliament team to make further efforts to locate a response, and indeed he responded. That response came on the day before the inquiry began. I think it was the 6th of October. And there's been a consistent theme. Like I said, the members have got the benefit of the correspondence. Two things in the main. The first is that the committee is acting outside its powers by conducting this kind of inquiry into the financial affairs of the Road Accident Fund. The second deals with and I'm dealing with this thematically now. The second deals with documents that the former chief executive believes he is entitled to in order to prepare adequately. And the third issue is the issue of a date, which means once he feels that he is ready to appear before the committee, then he will tell us on which date he is available. So as a principle, what we do, firstly, and I'll say what decisions we need to consider here, but there are several principles that inform how we are doing this, that everyone who is going to appear before the committee has the benefit of the same documents that we have. And that is anything that the Road Accident Fund has sent to us, anything that has been submitted by the public to us, and any other information that's other redactions of the particular details of those people. The people that we invite have the same information that the committee has. The committee also gets information from the people that testify before it. And therefore, it is not possible to suppose that we know what witnesses are going to say next week. But to the extent that there are statements that are submitted by those people, those statements are equally shared with the people affected by that statement, so that they may also consider the last one is that once the report is in draft form, ahead of its adoption by the committee, the people against whom there are adverse conclusions will get an opportunity to look at those parts of the report and provide further information or comment to the committee so that it may be incorporated before the committee votes on it. That does not mean that the committee will necessarily agree with them, but it will be noted that on this part, this person has raised it. But that is a process finalize a report. The last thing I want to say is that, of course, as I've said in the committee, and some members of the committee have raised the issue of working together with is ahead of the inquiry. In fact, even before we took a decision to have an inquiry, I was sharing information with the portfolio committee on transport, with the chairperson of the portfolio committee on transport. We had a meeting, a formal meeting, face-to-face with the chairperson of the standing committee of the committee on transport, and I took him through the rationale, the terms of reference, and so on, and he expressed his support. We also agreed that members of the portfolio committee on transport are welcome to participate in the inquiry. He has participated in the inquiry. I believe Honorable David Skosana is a member of the portfolio committee on transport, and Honorable Lucky Montana has also been participating. In terms of the rules of parliament, there is nothing that says we cannot look into the specific affairs of into the financial affairs of any state entity, following on our mandate where we consider financial statements, audit outcomes, and so on, and then do further oversight work. Sorry, the final thing is that, of course, this is an enhanced oversight. This is not the same process that, for instance, the ad hoc committee is running with an evidence leader, or a Section 94 inquiry where we're going to find someone guilty or liable. This is for the purposes of making recommendations to Parliament, to the Department of Transport, to the President, or whichever the case may be, and also to the Road Accident Fund. And we use those recommendations to the extent that they are adopted by Parliament to conduct our oversight further on the entity and any other entity that may fall into the same category if it's relevant. So that is...
Sorry, Chair, you're not audible. I think perhaps if you could switch off your video. We're struggling to hear you, sir.
Honourable, our power's just been switched off at Acacia Park, so our Wi-Fi, luckily my modem for my phone is still online, so I don't know if that's because of this and discussion, but it seems like Acacia Park is without power now. Can you hear me?
We can.
Okay, so
We can hear you, but we can't hear the chair.
No, because I think maybe he was on Wi-Fi, and the Wi-Fi has just gone off in Acacia Park. We've got no power. It's just been switched off. So I have Wi-Fi here, so I immediately went off, but reconnected onto my phone. My phone is a Wi-Fi modem. So I'm now acting on I'm connected through my phone. It's interesting that we have no power in Acacia Park.
At the time of the scope of inquiry?
Yes, on this particular discussion.
Absolutely, I know. I'm
is
thinking
this
the same
power
thing
live?
as well.
Are we live? Are we live? Is the public listening to us?
I believe they are.
Yes, we are live, and South Africa is listening to us.
Okay, well, so therefore, unfortunately, we have a power failure, and I think, yeah, some of us who are on Wi-Fi. I have an inverter, but here we go. So we'll just have to wait for the chairperson.
Morning, members. I want to propose, why don't we take perhaps a 5 minutes break? I think the chair, and then we will try to get hold of him on the side, and then we'll resume. Just don't exit, but take a 5 minutes break.
Yeah, I think it's a good idea.
I agree.
Definitely seems to be something wrong. Yeah.
No, thank you, members.
Thank you.
Okay. My apologies, honorable members. I don't know if any other members were affected by the power cut. There's a power cut at Acacia.
Okay, we are affected, and we've taken a 5-minute break just for everybody to be reconnected.
Oh, thank you. Thank you so much. Jeez. Yeah, everything just went bum.
Yes, so we're on a 5-minute break, Chair, to reconnect.
Thank you, Chair. So I suppose you are chairing in the meantime, Honorable Nilmay.
So
No,
Chair-
that
Chair,
was Maduna chaired.
Honorable Maduna took over.
Chair, I think we can continue.
I think, Chair, if everyone is still in, maybe perhaps they can just confirm for us. If everyone is still in, Chair, I think you can continue.
It's 5 minutes over, Honorable Isaac.
No, it's not.
Okay, no, thank you
over,
very much,
Chair.
Honorable
But
members.
I'm saying, let us just...
I think... Sorry, you're saying, Honorable Madun?
I'm saying, Chair, let us just confirm if everyone is still in. If everyone is still in, I think we can continue.
Oh, I see. Let me actually have a look on the list here. I think so. So I'm going to switch off my video so that we try and save bandwidth. Yes, Honorable Maduna, I think everyone is still in. If I'm mistaken, I apologize, but I think there's about 10 or 11 of us in the meeting. So I was concluding, members, to say, so I've outlined the process that we're going to go through, and we have made clear to everyone that our intention is to make sure that everyone who is affected gets an opportunity to put their side of the story, firstly, and secondly, to do so orally or in writing, in addition to have it made an oral submission. If they can't remember something, they will need to go and get the information and so on. The final thing I want to say, which I reiterated to the chair of the Road Accident Fund yesterday, is that for anyone who is no longer at the Road Accident Fund, and that includes board members or previous board members, it is important that the Road Accident Fund cooperates with them to provide them with documentation they may need in order to prepare for their appearance before the committee. We have had no difficulty with that undertaking from the Road Accident Fund. So what I'm trying to say is that on our side, as the Secretariat, as well as a Parliament legal team, we've taken all reasonable steps to make sure that we are as fair as possible to everyone, while also conducting a process that is going to be expeditious, because we do have other areas of oversight that we have to do. And we've set this time aside for the Road Accident Fund inquiry and need to be done with it within a reasonable time so that we can then prepare our report and move on to other things as well, because they are equally important. The implication of this is that we may therefore need to consider a subpoena, which is a serious step. I would prefer that none of the witnesses need to be subpoenaed at all. But the difficulty that I foresee right now is the big one at the top, which is the committee does not have the power and the authority to do what it's doing. And I need to place that. We'll come to the documentation and the time. That's the first thing I would like to get the views of the committee on, which is that we should not be doing this inquiry. Only the Portfolio Committee on Transport should be doing this, not ourselves. That is not our understanding, at least as far as I know, which is why we resolved to have an inquiry, and also looking at Scopa's oversight over the years, including going to the Road Accident Fund itself or calling officials and board members of the Road Accident Fund in the past. So that is the first thing I would like to put to the members for discussion, because we need to respond to that. In my view, if we cannot resolve that, in other words, if between ourselves and the former chief executive of the Road Accident Fund, Mr. Litswalo, we cannot resolve that, everything else that he raises in his letter, such as access to documents and dates, becomes moot, because fundamentally he believes that the committee has no authority to conduct this kind of inquiry over the Road Accident Fund. So let me take the views of members on that aspect. Like I said, I am not going to go through chapter and verse of the letters. The members have them, and you can have a look at them and then make your input. Honorable Isaac, I see your hand. Honorable Beasley. Okay. And Honorable Skosana. Let's take those three for now. Let me hear it from you, honorable members. Honorable Isaac, please go ahead.
Good morning, Chairperson. Yeah, and thank you again for the opportunity. Chairperson, look, quite frankly, I mean, there is really no strong argument or case here, because if, and this is in my opinion, the CEO of the ex-CEO of the Road Accident Fund or board members that were previously there, if the contention is that they should not be appearing at Scopa, and that this matter should be handled by the Transport Portfolio Committee, I mean, the logic must remain. Why then did they appear before us previously if we were sort of not the entity to be reporting to in the first instance? So, that argument, in my opinion, does not hold any concrete justification, because they have appeared before in front of us. And of course, as Scopa in the 6th parliamentary term, they've reported to Scopa as well. And as you alluded to, they were oversights. So briefly on that point, I think that argument does not really hold or stand. Secondly, Chairperson, the issue of dragging this matter, you and I think my fellow colleagues on the committee will full well be realizing that there will be individuals that will try and procrastinate and drag the matter. So unfortunately, it's not a very nice thing. But if it means that one has to look at subpoenaing individuals, then, well, so be it, Chairperson. That is our duty. It's our duty to Parliament. It's our duty to South Africans as a whole. And then thirdly, Chairperson, we will discuss this off the record, but perhaps we also, for the benefit of all members, need to think about doing a visit to those offices at some time when it works best for the committee. That's my input. Thank you, Chair.
Thank you very much, Honorable Isaac. Over to you, Honorable Beasley.
And thank you, Chair, and greetings, colleagues. So, Chair, I'll just be brief. As Action SA, we fully endorse the powers of Scopa to undertake this inquiry. So we of the view that it should continue. and we have no concerns with that matter at all. So in terms of that point that you raised, we fully support the ability of Scopa to undertake this inquiry, and we don't believe it's a sufficient legal compliance issue for us to undertake this inquiry. Thank you, Chair.
Thank you very much, Honourable Beasley. Honourable Skosana.
No, thank you very much, Chair, and good morning to yourself and to all members, the technical team and everybody. Yeah, no, Chair, I think we are within our powers as Scopa to conduct this inquiry. And as Scopa, you must remember that we are a committee of the National Assembly. So we report to the National Assembly. And the House Chair, Honorable Frolick, has been given a responsibility, a delegated responsibility by the Speaker of the National Assembly to oversee the work of committees. So if we are outside our mandate or outside our scope of work as Scopa, I think it is Honorable Frolick as the House Chair who is responsible for committees and or the Speaker of the National Assembly that will tell us that we are now outside our mandate. What we are doing is not within our mandate. And I think we have indicated in some of your letters, in one of your letters when we were responding to him, that already the Speaker has expressed a view with regards to that in response to the letter that was written to her by the economic freedom fighters, where the Speaker clearly indicated that no, Scopa, it's within its right to conduct this particular inquiry. So I'm also of the view that we are within our right to conduct this particular inquiry. And I'm quite surprised that Mr. Litswalo is talking about rules of parliament. Well, I think his interpretation of those rules is not correct. But I'm just worried why he's so raising the issue of rules. At least if he was raising the issue of the Constitution as the citizen of South Africa, to say, in terms of the Constitution, I've got the right not to appear, or in terms of the Constitution, Parliament has got no right to conduct this. But he's busy talking about the rules that are governing Parliament, rules that are governing the behavior of members of Parliament, members of the National Assembly in particular, and the committees and all other structures of the National Assembly. So instead of talking about the Constitution, if he was talking about the Constitution, at least we can say, hey, maybe let's hang on and look at what is it that we're not doing for it. But the rules that he's talking about are the rules of Parliament. Now he's being required by a committee of Parliament. Even if an error can happen, that it is a wrong committee that he's inviting in, but it is a committee of Parliament. So he's got a responsibility to come and appear before a committee of Parliament. So as to whether which committee was supposed to do or not, I think for me it's secondary because he is being invited as the former CEO of the Road Accident Fund. And the rules that is relying on, though he is misinterpreting the rules also, are the rules of Parliament that govern members of Parliament, committees of Parliament, and structures of Parliament, are not the rules that govern every other citizen. They are not the Constitution of the country. So thank you very much, Chair.
Thank you very much, Honourable Skosana. Honourable Atkinson.
Thank you very much, Chair. I don't want to repeat what the Honourable Skosana and the other members have said, but I think it is quite clear that this matter has been legally canvassed with Parliament, and I must say I have full confidence in our legal advisors and in the opinions expressed by Parliament. We do know Mr. Litswalo to be a very litigious character, and at the drop of the hat does try and revert to the law or try and use the law to his advantage, when in many instances it's not the correct procedure to do that. And I really think this is just really an extension of what we've been seeing in the committee over the last 2 weeks, particularly when that issue came up with them taking the Auditor General to court over the accounting principles that they had to follow, and we came to hear that he'd been basically fighting the wrong entity throughout his entire case. So I think generally his his legal cases and legal submissions have generally been wrong-headed and not with proper advice. And I must say, I think in this instance, it's exactly the same situation. I think he's wrong-headed and he's not taking proper advice. The other point is, as we all know, what the divisions are between the Transport Committee and SCOPA. Transport looks into the actual running of the Road Accident Fund, the legislation that governs it, and is involved in the day-to-day procedures of how the Road Accident Fund actually does its business. Our task, as we know, is to look at financial malfeasance and at issues of corruption and particular issues where there's blatant issues of procedures and regulations being not been followed. And I certainly think everything that we've been doing over the last 2 weeks is wholly within that limitation and that request. We're not giving an opinion on the RABS bill or telling Road Accident Fund how they need to do their business in future. We're merely taking evidence of what has been happening in the past, and we will come up with our recommendations in line with the mandate of the SCOPA committee. So I'm fully of the opinion that we are absolutely entitled to be doing what we're doing, and maybe Mr. Litswala needs to think again about the legal line or the thought that this committee is in any way not legally mandated to do the job that it is. Thank you.
Thank you, Honourable Atkinson. Honourable Neil May.
Good morning, Chair. Good morning, colleagues. Let me add my voice to the discussion that we are having now. Chair, once again, I want to confirm that, yes, we do have the constitutional oversight. And in terms of Section 55, 2 of the Constitution, the National Assembly must provide for mechanisms, A, to ensure that all executive organs of state in the national sphere of government are accountable to it, and maintain oversight of the exercise of national executive authority of any organ of state. The Chair, as we all know, the Road Accident Fund is an organ of state established under the RAF Act. Therefore, SCOPA, as Parliament's Financial Accountability Committee, is constitutionally obliged to continue exercising oversight until all matters of financial mismanagement, governance failures, and audit concerns are addressed. And once again, Chair, mandate of SCOPA in the National Assembly, Rule 252 of the Rules of National Assembly, empowers SCOPA to examine the financial statements and audit reports of all national departments and public entities and to ensure that corrective measures are implemented. Chair, therefore, RAF inquiry falls directly under this rule, as the Auditor General's reports on RAF have highlighted irregular, fruitless and wasteful expenditure, non-compliance with the PFMA and deteriorating audit outcomes. Chair, therefore, discontinuing the inquiry before these matters are resolved would be contrary to SCOPA's standing mandate. So, Chair, I would say let us continue. Thanks.
Thank you, Honourable Neil May. Honourable Mente.
Thank you, Chair. Good morning, colleagues. Thank you, Chair. Now, Chairperson, I have two difficulties. This is exactly the reason why we wrote to the Speaker asking the authority that SCOPA has in many aspects of conducting this inquiry. And rightfully so, SCOPA has conducted many inquiries before. I've been a member of this committee since the 5th Parliament. And we have conducted inquiries. But one thing we have never ventured into are judgmental inputs and character assassination. Once members of Parliament have got a certain attitude against certain officials and members, you drive a situation where people will be defensive and people will have to be extra cautious about coming to SCOPA, because they will not be coming to answer on the basis of a recommendation, but they will be coming to be character assassinated. And that is not our duty, to character assassinate. Our duty is to make sure that finances of the country are spent wisely within the rules that are governing expenditure of this country. And we cannot then have a situation where we want to do things that are not within our scope. Let me make an example. We have workers of RAF, rightfully so, that are giving us, or rather voicing their frustration, some of them sitting at home with CCMA orders that they must go back to work. We can't do anything about that. We are not portfolio committee. We can't sit with finance and HR and ask them, HR, why are you not doing this? Painfully, we have to tell them that that is not what this inquiry is about. Simply because we've given hope to people that we will do something, we don't have a right to re-employ those workers. And those workers have got legitimate unfair labor practice issues. They came to us. So our end game must never seek to character assassinate, must never seek to judge, must ever seek to uphold the principle. And the principle is that we want to deal with corruption. And if there is corruption rearing its ugly head, we deal with corruption. Now, coming to the letter itself, I was plainly giving a background on exactly why we wrote a letter, because also it is not true, Chair, that the members of Portfolio Committee, yes, they are participating, but we don't have a collaboration. This is going to be a report of SCOPA, not a report of both SCOPA and Transport, no. They are just here as members of parliament, just like any other member of parliament can come to this inquiry, as a member of parliament can have a view. Because as a member of parliament, you can participate in any committee in parliament. Not unless that committee then decides otherwise. For instance, what the ad hoc committee is doing, that now will deal with the members and whoever is given to us as a representative and as well as an alternate, but not everyone can participate because it's going to be longer. But ours is just SCOPA. And what is SCOPA mandate? Is exactly what we do, is to look after the expenditure framework of the country and that it is implemented accordingly. And correctly so, we will do that. Now, on the letter, Chair, there is 2 sentences that we are not being explained on. Because when I read the letter, there is nowhere which it says the former CEO doesn't want to come to Parliament. At number 8, he says, I informed you, which means you, Chair, because this conversation is between yourself and him. I informed you I would keep the 4th and the 5th of November open. While seeking legal advice, meaning which in the interim, I'm seeking legal advice. Yet you object and claim I was unwilling to attend. You also mentioned Parliament's intent to issue a subpoena, which, if necessary, can be contested. You see, now this is what I'm saying, that we should not have this character against people. Now we are going to have subpoenas that are contested and drag this whole situation at court. Number 9, he says, I remain committed to reporting in Parliament on the decision our team made to improve the RAF since 2019. This is a person who says, yes, there are allegations against me and I take them. But since 2019, we also worked there and we want to come and answer on our part. The facts are unchanged, regardless of rumors or misleading claims. And then he goes on to number 10 to say, while I await my legal counsel, please instruct RAF, that means anyone from RAF who have produced information, DOT, and SIU to provide the necessary information so I can prepare my affidavit and responses. Then he lists all the allegations that have been, and then 6 extra documentation that is in our position and that he does not have, so that he can also make an informed decision and give us informed answers to the allegations. This is not a got your game, we got you. Its ultimate end game here is that he must come and answer. And he cannot come in the middle. He must come at the end, after all the accusations have been penned against him. So, Chair, I do not know why we are here in terms of a subpoena and what decision must we take. If anything, I think my suggestion would be present this letter to legal and say, legal, this is what the witness is saying. And in terms of our time frame, this is the situation we are facing. Where is the fair practice in this letter and where is the unfair practice in this letter? And also raise our time constraints, that how do we then best deal with it? Thank you, Chair.
Thank you very much, Honorable Mente. Honorable Madlala.
Thank you, Chair, and greetings to the colleagues. I want to first state that at the beginning of this inquiry, or maybe let me start here, the role of the Department of Transport, I think we need to try and, not department, but the Transport Committee, we need to try and clearly define their presence in the committee. This issue of the legislative mandate obviously borders across both the committees, because as a committee, we are looking at the entire issue of RAF, and I think if we're honest about how we've been conducting the committee work, we've spoken about the systematic issues, systematic failures, the legislative gaps that could possibly be there, the financial issues, irregular expenditures, and all of that. As Honorable Mente is saying, also there are some other litigation issues, human resources and human capital, labor relations matters that are coming through. So we've opened the scope to the public, for the public to make input, and we're inviting law societies and so forth and so on. So it's quite a broader mandate than how ordinarily we conduct our oversight. So the technicality of whether it is the right committee or not, I think it may be brought by such a broad mandate that we have taken upon ourselves. And we would recall as a committee that we had raised some of the issues at the beginning of the inquiry as the party, as the MK party around the issue. However, the majority seemed to have a keen interest in this matter. So I just want to say, as I go through the letter myself, I think we can note the concerns that are raised by the CEO at this point, because we already made the inquiry. So it is neither here nor there whether we proceed with it or not, or whether we think it's within the mandate or not. So we can note the issues that he's raising, but I have also not heard where he's saying that it's not coming. So he's saying, notwithstanding his reservations around the particular contravention or overlapping of duties between the committees, he has a right to his own time and to manage his own time. So we can say that we are constrained by our own time frames and all of that. So we request for his consideration also of that. Maybe if he then resists, then we can look into those subpoenas which may be challenged and so forth and so on. But our approach, I also want to just make a request whilst on the same point, that whilst there are labor relations issues, CCMA issues, and many other issues that are coming forth to the committee, it should really should continue to appear, and we preserve that principle of objectivity and of not looking into specific cases. And I think, I don't know, to some extent I've felt that some of the members actually have some conclusions in their own minds about what was happening at RAF. So we've noticed submissions, we've noticed sensitive matters as they come and very passionately coming through. And some of them will be litigated through courts and all of that. And that is not what we should be diving into. And we must create an environment where everybody feels that they are not jumping into a lion's den, but they are jumping into a situation where they can express themselves freely without prejudice or without prejudgment, and recommendations would not be cluttered or will not be structured to persecute them. And I think that element of discomfort is what we need to deal with. So we at this point, I'm totally opposed to an idea of a subpoena. I think that there are concerns that have been raised. The inputs by committee members from various committee members, including from the beginning till now, seek to say the speaker is given authority and all of that. So legal can compose that into a response to say, look, we believe that structurally we have been mandated, and we then try and fine tune or clearly express the role of the transport committee, that we're in engagement with them, they are part and parcel of us, but also just try and formalize that so that it is clear. And tomorrow the portfolio committee on transport does not say no, we were just visiting. So we're not part fully, we're partially invited into the process. So we can clarify that, but then work around the issue of the dates that the CEO is speaking about. He has left the dates open. You have given assurance, Chair, that the RAF is available with the documents to provide as part of the thing that the CEO is saying that he wants. And we try and not antagonize the situation. We give it a playing field where everybody would feel comfortable coming through. If following that letter or that response to this correspondence, then we see that there's any element of resistance, then we can venture into considering possible legal options also that are not going to delay the output of this committee, so that we're able to make recommendations in timely and ensure that we're able to move out of the situation. We still have got quite a lot of other issues. While RAF is an important issue, and we had said this before as I close, while RAF is very critical and they're very sensitive matters, and we don't take those matters lightly as members of the committee, we've got a society that is clustered with a lot of issues, from water crisis that is affecting 10 times the millions of people that are affected by RAF. We've got many issues that I believe, or we have also held a view that we need to try and zoom into with an agency that is required. Thank you, Chair.
Honorable members, thank you very much. Let me say the following. I think, so the reason I asked the question about the jurisdiction of the committee is because it's a fundamental issue. Mr. Litswalo's willingness, in his own words, is to appear for an appropriate forum. So we need to read his willingness to come together with his view that this committee does not have the right or the authority to do what we are doing. It's a fundamental question. I'm going to come to the other issues. And the question I pose to the committee is whether you agree or disagree that our only mandate in his definition is to consider the financial statements and audit reports and do nothing further. This work that we are doing arises out of presentations done to the committee by the Auditor General and by the Special Investigating Unit. I do not see anywhere where it says once that meeting with the Auditor General is done, and we have had a session with the Road Accident Fund where we are given inaccurate and incomplete information, our hands are tied. We are not able to do anything further because we must limit ourselves to the audit outcomes and the financial statements and do nothing further, do no further inquiry into matters arising out of the same. So the fundamental question I was asking is whether the members believe that that argument is merit, that we have no authority. The Portfolio Committee on Transport should rather be doing this. That is his view. It's a point of disagreement between ourselves as a committee and him. If we cannot resolve that issue, sending documents and everything else is moot because he believes we are illegitimate in this context. I understood the members who then gave a view to be saying the committee does have the mandate to do what we are doing. We will come later, colleagues, to what steps we need to take, and I appreciate the recommendations made in terms of what we do going forward. But I just wanted to clarify, because everything turns on that first point. That's the first thing. I think let me then respond to the other statements made. I think over the last 5 days of hearings that we have had, I have not heard an objection from any of the members in respect of how the proceedings have gone. We have been at pains to say that this is an inquisitorial process, not an accusatorial process. We've encouraged the witnesses to relax, to be simple in their explanations, and so on. We are not trying to find them guilty. This process so far has been useful in the sense that we have already picked up contradictions. Last week, we were told that, direct claims, are encouraged and so on. This week, direct claims are not encouraged. The members have a view on it, right? But this is part of the process because we need to get to the bottom of what really happens. The point I'm making is that we have made the environment as accommodating as possible for people that appear before the committee. Third, we've also made clear, and I've made clear to the witnesses, as you saw repeatedly, that unfortunately, we cannot review labor cases in the committee. To the extent that people mention that they've been suspended as it relates to the governance issues, sure, but this is not where we ventilate who is correct and who is not correct. And I certainly personally have not expressed a view about whether a labor practice has been unfair or not. And it's not because I don't have an opinion, I do. But it would be inappropriate for me, after having said we are not reviewing labor cases, to then make a judgment about whether the suspension has been fair or not. I, however, cannot stop members from making similar judgment calls, but that's not how we have intended. I can't cut members off when they are talking. I have to give them the floor unless they say something unparliamentary. Otherwise, give the members the floor to ask questions and the witnesses must answer. So I haven't seen anything in our conduct of the inquiry. The next response I wish to make is with regards to the Portfolio Committee on Transport. Let me then explain the steps. The first point of call was the House Chair. The House Chair concurred after consulting the rules. The next was the chairperson of the Portfolio Committee on Transport. We met in the House Chair's office. We went through correspondence together. We went through the terms of reference together. I explained what process the committee is intending to undertake, and the chairperson of the Portfolio Committee on Transport raised no objection to me. Absent of that objection, and my belief that it is also his view, following whatever advice he is entitled to take, he was comfortable that we undertake this process. And as an MP, he has also been participating in this process. I think then I would be correct in assuming that the view is that this committee has the authority. That's the first thing I've asked as colleagues to opine on, because it's a fundamental issue. I am coming to the next issue about documents and so on, and I'm going to then set out, and then the committee can take a view on what we should do next. The last thing I want to say is that we had to let Mr. Litswalo know that one of the options available to the committee is a subpoena. What we cannot, I believe we should not entertain, is a situation where a witness says, I want to look at the documents, and then I will tell you once I am ready when I will be available. And the witness tells us, I need until March 2026 to consider these documents. Then I will tell you which date I will be available, which will be in June because I'm busy. You don't control my time. And I want members to be cognizant of the testimony of last Friday from Advocate Motibi, specifically as regards to the level of cooperation the SIU has not received from the former chief executive. They've been looking for him since June last year. It is now October of the following year. They have not had a substantive conversation with him. Still, he told this committee. So what I'm trying to say, colleagues, the reason I felt that it is important that we deal with this matter of whether we have the authority or not is because it's fundamental. We have to take a view on it. So the option we have right now on this matter is for me to ask whether then any of the members, after me having outlined the steps that have been taken, including the speaker getting involved in response to a letter from one of the political parties represented in Parliament. So Speaker, House Chair, Portfolio Committee Chair on Transport, Honorable Slamlel, all of them in agreement. So my suggestion is that on this point, and I'm tabling this before the committee, in writing back to Mr. Litswalo is to say, because I don't want to say this under my own jacket, the committee has considered your view that it has no authority to conduct this inquiry. And it is of the view that it actually has. It has the authority to conduct this inquiry. So we disagree with you. That enables Mr. Litswalo to take such steps as he feels are necessary to dispute what we are saying. Maybe he will go to court. But we can't avoid this point. So that's my proposal, colleagues. On this point only, it's not a complete letter. I'm going to come to the other points. On this point, my proposal is the committee is of the view that it has the oversight authority to conduct this inquiry. We've already decided to have an inquiry. The committee voted on it. The committee deliberated on it and agreed. So on this point, can we write a letter to Mr. Litswalo saying that? That's a question. And I understood most of the members to be saying, yes, we should. But I just want to have Mr. Madlan.
Thank you, Chair. I think what you are quite right on is the fact that this committee dealt with that part, and the matter was voted on, and the majority agreed that the inquiry should be there. So we wouldn't be engaged in a process that, as a collective of the committee, with the majority having supported that it must be pursued, is illegal. I think that's an automatic stand that we are only in it because the view of the majority, which thus becomes the view of the committee, that this is a legal process. So I think that is just my comment to say we can't, as a committee, say that we think you are right to engage in an illegal process because we had considered most of these facts, including the steps that you had brought forward. However, the reservations were along different opinions and all of that. But in the collective of the committee, the ultimate view was that the inquiry proceeds. So I think your last part is on point with regards to that. We can't start now and say no, but we think as individual members of parties we agree or we disagree and all of that. There is a view of the committee, and democratic centralism dictates that we must all of us subject ourselves to the decisions of the majority. So let me just pause there. Thank you.
Thanks very much, Honorable Matlala. That's really helpful. Honorable Skosana.
Yeah, no, thank you very much, Chair. I agree with you, and I also agree with Honorable Mazala that, in fact, the fact that we are doing this inquiry, it is because we have already taken a decision as a committee. And before the decision was taken, we are thoroughly engaged on the matter. We look at different alternatives of dealing with issues at SARS, and then we ended up taking a resolution that we should engage in this kind of inquiry. So I think there's no question about that from where we are seated. But well, maybe as a KTC, and also just to firm up your previous response to him, because I think there are three letters from each side between you and Mr. Litsualo, where you wrote to him and then he responded, you wrote to him, he responded, and stuff like that. Maybe if he can get another letter that is coming, that emanates from a fresh resolution of the committee, that we have taken note of all the issues that we have raised, but as a committee we still stand by our resolution that we are conducting this inquiry, and definitely we are continuing, and we believe that we are correct. And clarify and further clarify the involvement of the Honorable Speaker, the House Chair, the Chairperson of the Portfolio Committee on Transport. Just as a courtesy, it's not necessary, but as a courtesy, I think we can do that. I don't see a problem. Thanks.
Thanks, Honorable Skosana. That is noted. Honorable Mende.
Thank you, Chair. No, Chair, we have already made ourselves clear where the scope of the inquiry is concerned. Hence, we wrote a letter as EFF to the Speaker. And broadening the scope of this inquiry and venturing into everything else, which also gives a false hope to people to make submissions to us, submissions that we will hear, but will not do anything about them, is equally wrong. Because we are hearing things that we can do absolutely nothing about them. And if we want to rescue this situation, my suggestion will be, let's have a joint inquiry with Portfolio Committee of Transport, not them as invitees. Because ultimately, everyone, when they come, even the board, the minister, and everyone, all these documents and the information and the labor issues that we've had, we are going to have to place them before the executive, before the board. And ultimately, they must say something about them. But we're going to be asking them things that we can't do anything about them after all. We cannot summon HR of RAF to come and appear before SCOPA. Not unless we are only going to be subpoenaing them for the salaries they pay for workers that do not want to work. But beyond that, we can't ask anything else in terms of merits of the cases and everything, because ultimately the workers must be reinstated, those that are qualifying to be reinstated, but we can't drive that. I said our end game should not be forced at getting at a point where we are not even helpful. Because if we want to push this thing and even enforce it, when we see ourselves that we are now trapped into issues that have nothing to do with financials, but having everything to do with the operations of RAF. Operations of RAF have nothing to do with SCOPA. But those things have been placed before us. Hence now there is a confusion of what must we do going further. Simply put, Chair, is that we've got all this information. And the CEO rightfully is asking, okay, what will you be asking me as SCOPA? Are you going to be asking me finances? Yes, because I must account to you about the finances. I must account to you about irregularities and ages, out findings and everything and all of that. But I will not account about a worker who has got a CCMA order to go back to work, because that thing of finance must go to transport. So you see, we also need to look at how do we make this thing possible. So how do we make it possible? We ought to have now a joint committee with transport, and then we can then accept everything and deal with everything so that we make an informed decision at the end of the day. And we do not make other people feel hostile, and we don't drive hostility. We don't have to be character assassinating, because if we stick with principle, we're going to find a very beautiful end game. Thank you, Chair.
Thank you very much, Honorable Mende. I do wish to say that I agree with you that the scope of the committee is limited. It is precisely why there are several inputs that we have turned down. And in the statements provided to the committee, quite a lot of what falls outside the scope of the committee has been removed. We are not entertaining individual claims. We are inundated with letters from members of the public and lawyers and so on inquiring about their claims. We are not dealing with those. Those must go to transport. We have lots of submissions from people who are complaining about their labor relations cases. We do not deal with those. Just to clarify, we are concerned with people that have been on suspension for a long time. The Road Accident Fund says cases must be resolved within 60 days. The committee has heard that some people are on suspension for years. That's what we are interested in. It's the expenditure. It is the expenditure on lawyers and counsel when it does not appear to be necessary for the purposes of an internal disciplinary process. That's a financial issue. I'm trying to say, Honorable Mende, that is the limited nature of the scope of the committee. Anything that falls outside of that scope, we sent to the Portfolio Committee on Transport. We forwarded a lot of correspondence to that committee for precisely the reasons that you are stating, that we are not looking at such things. They are not for us. That being the limited scope of the committee, it is therefore unnecessary for us to expand the scope of the committee by involving the Portfolio Committee on Transport, so that we have a long, protracted process that is of little help to the Auditor General and the National Treasury in conducting their work within the short term, because then we will meet, in my view, Honorable Mende, until June next year. The Portfolio Committee is at liberty to conduct its own process on matters that fall outside the mandate of scope. But that's my view. Honorable Maduna and then Honorable Atkinson. And then we'll have to move to the next leg of the discussion.
No, thanks, Chair. I think in line with what, good morning to members and members of the panel. I think in line with what you've just said, even some of the employees of RAV have been on suspension with pay for years. And I think that relates to a serious fruitless and wasteful expenditure, because RAF is not deriving any value from paying people who are sitting at home. I remember there was one employee, when he was speaking, he said she only remembered RAF on the 25th. I make an assumption that it was because it was when she was being paid. No, Chair. I think I've been quiet, especially on around the issues of composition, because largely leadership was on the international stage during that time when this matter was discussed, representing obviously our people in matters of peace. No, Chair. I think also Honorable Skosana correctly presented what would have been the ANC view on the matter, of which we fall under. That the composition of the committee was supported, and the view of the Congress movement would have been that it is in line with the duties and what we are supposed to be doing in Parliament as well. Two, I think, Chair, majority of actually almost everything that we have touched on in the inquiry until now relates, it's either to financial management generally. Obviously, you can go to categories under it, which is expenditure, revenue management, and so on. However, everything that we have dealt with has something to do with the process of financials and how money has been generally managed at RAF. So that's one. Two, I do not think it is a duty or Mr. Litswalo enters anywhere in him pointing us in terms of what we can or cannot do as members of parliament, because I do not think it is even his place for us to be explaining to him how did we arrive at the process of having an inquiry, because it's us who are playing an oversight on him. But perhaps for issues of transparency, we may, as a KTC, just be open to him. How was this process followed that we ended up having the inquiry? However, I must say that the tone of his letter as well, to me, sounds very arrogant and incorrect. That I must say. Lastly, Chair, I think in line with what Honorable Madlala have raised, I think in the committee as well, I've noted this, that we do have some members who appear to have already taken a particular posture or a particular view on matters just before people even present them, or witnesses even present their case. And I do not think that is ours. What is important is that the committee must create a conducive environment for everyone to come and present evidence and be able to be heard honestly, fairly, and squarely, without feeling like we've already made a decision about the case that they are coming to present, so that we can be able to derive and maybe to prepare a proper report according to the issues of RAF. But I think I just wanted to register that so that honorable members are also not surprised as to why I am not sharing my views on the matter. And lastly, I think in line with what you are saying, that we must revert to him, I think it's important, because I do not think it's going to assist us for us to wait for the time frames that he gave us. Perhaps this is an ongoing engagement that you must have to him, that these are the dates that we think that we can take you in, or that are available for you within the limited scope, and then you can discuss around that which dates. Failing of which, because I do not think it's incorrect for him to determine which committee wants to come and appear on. Lucky enough, I sit on transport as well. I do not think it's for someone that is appearing in parliament on any other matter for that matter. It can't be that person that tells parliament what committee they want to appear on. So he must come appear to the committee. Because the inquiry now is it. We can't make it a joint inquiry. The process already kickstarted. So I think the engagement that must happen now, Chair, is between you and him, to say, when you revert to him, to say these are the dates that we have, pick the ones that you would have available, failing of which then we can move to the issue of just subpoenaing him. And then we take it from the process. There are many who have not appeared in commission of inquiries in the country, who have refused, and we know what happens when people refuse to appear before inquiries. Thank you.
Thank you very much, Honorable Maduna, and thank you also for the injunction that as committee members we must just manage what we say about people who must still come to the committee. I think we can reach our conclusions on the basis of the information that has been presented to us. But I just think, in the interest of fairness, we have a responsibility to be circumspect, especially when it comes to individual conclusions. Honorable Atkinson, and then we'll move on to the next 2 points.
Yeah, I just want to support your earlier points. I think the important thing to note here in the discussion about talking about HR matters, none of those people that were asked to appear before the committee actually came in to talk about the HR matters. They came in to talk about contracts. But I think the important thing to note is that through the evidence that they gave, and particularly the one person that appeared on Wednesday, she kind of went quite a way beyond what we had asked her to come there for, and gave us a lot of very useful information, as did Mr. Palela too. And actually, in a sense, contradicted everything that the Road Accident Fund had said the week before. So, one doesn't have control over what people say in inquiries, and quite often it's the information that is not necessarily sought, but given, that is sometimes even more valuable than the information that is sought. And I would say probably what happened on Wednesday, it really, really opened the door to something that we hadn't actually really been looking at, which was an absolute waste of money of a lot of people who've been on suspension, and fruitless and wasteful expenditure being incurred by RAF in that particular line. So while we were actually looking at specific contracts, another whole new avenue had been opened up. I don't think at any time that anyone that was appearing before the committee actually assumed that we would be able to sort out the HR problems. I mean, that's not who or what we are or hold ourselves out to be. But obviously those matters do come up, and they were very important in the line of fruitless and wasteful expenditure on the incredibly high levels of suspensions. And I do believe that apparently one of the reasons why just recently a number of those people saw some movement in their situation was that the present board that's just been appointed was very uncomfortable with the amount of outlying cases, HR cases, basically, and felt that they should be brought to conclusion. But anyway, all that said, I just wanted to support everything that you had to say in your statements earlier on. Thank you.
Thank you very much for the guidance, honorable members. We will respond on this point accordingly to Mr. Letsoalo, and we'll copy you. We'll send you a copy of the letter as a whole, but it's got other aspects, of course. On the issue of the information that Mr. Letsoalo is seeking, there are two things. One, every document that the committee has in its possession, we can only respond to information that we have as a committee. We are not withholding any information. And if new information, for example, the instruction to the team is that when they distribute statements, as you will get today and tomorrow, statements for next week, similarly, Mr. Letsoalo and others will get the same information. So by the time somebody arrives next week to testify, the same information the committee is looking at, they will already have. We can make that undertaking. The second undertaking, and these are reiterations really, is that we ask the Road Accident Fund to assist. We've asked already in writing, and in addition, I have also impressed upon the chairperson of the Road Accident Fund to do this specifically, that to the extent that there are people who are no longer at the Road Accident Fund, either through suspension or through resignation, or their term has come to an end, they be assisted with information so that they can prepare to come to the committee. That's all we can commit to, members. Information that exists outside of the committee's own possession, we are not in a position to assist. And I don't think we should entertain requests for information the committee simply does not have. So that is the response thereto. The final point is that we then say, and I have to assure the members, we have been willing to negotiate dates with witnesses. The reason we don't have a solid cast in stone calendar until the end of the envisaged period of inquiry is because we understand people have commitments, people have medical appointments, they've got all manner of other things. We have to be accommodating as a committee so that they may also come in the right state of mind. So it's not for lack of flexibility. However, I think the committee needs to draw a line and say, we have limited time. We want to finalize this report this side of the year. And and table it to the National Assembly as soon as possible so that it can be adopted. We do not have unlimited time. Secondly, there are other areas of oversight that the committee needs to pay careful and serious attention to. Thirdly, there is the calendar of Parliament, which also demands that we perform certain functions, and therefore we don't have unlimited time. So your date of appearance, while we may negotiate, it's limited to a certain time period. And we implore you to come within this period and on the dates suggested. So basically, to the extent that he wants to suggest alternative dates, they must be within the period of inquiry. Failing which, then we will then as a committee have to take a decision to subpoena. And I believe we must also give him a time frame by which he must respond, so that the committee can then deliberate on a subpoena specifically. But I really want to assure members, we really, with everybody, have actually been quite accommodating. And when I look at what other committees do, I have to tell you that people get told to come on a certain date and they must come. So this is the totality of the suggestion that I place before the committee members. Can I just, for completeness, ask Ms. Ibrahim just to say whether we are leaving anything out in substance in relation to how we should respond to Mr. Litswalo?
Thank you, Chairperson, and good morning to yourself and the honourable members on the platform. No, Chair, I think you've covered the issues completely. The difficulty that we've had with the letters that we have received is that, on the one hand, Mr. Litswalo indicates that he wants to have his side of the story heard, that he'd like to prepare a statement, but on the other, he keeps insisting that he wants to do that with the appropriate forum. And it's clear if you read the letters in totality that the belief that SCOPA is not the appropriate forum. So where you have somebody saying, I am willing to account, I've even made these days available, but on the other hand, you're saying this isn't the appropriate committee, one doesn't know whether to read that as a commitment to coming to SCOPA on those days, or a commitment to appearing, but in another forum.
Yes, thanks very much.
Honourable Atkinson, please mute yourself. Please go ahead, Ms. Ibrahim.
So it is somewhat of a diluted commitment, Chair. I think that the response letter that is sent now needs to say that we need an absolute firm commitment on the date on which he is attending, and that attendance is going to be to SCOPA for purposes of this specific oversight inquiry. Thank you, Chair.
Thank you very much, Ms. Ibrahim, for that guidance. And can I just ask the members then, can we respond in totality in that way to Mr. Litswalo, that we furnish him with, oh, sorry, Ms. Ibrahim, and Ms. Ibrahim, and then let me take...
Apologies, Chair. There's just one more issue that I think the committee hasn't dealt with that appeared in the letter. And again, it isn't completely clear, but there is reference to Mr. Litswalo requiring legal assistance, I think, as he put it, as well as secretarial support to put together his submission. Firstly, there's no requirement that a statement has to be provided to the committee. Like the witnesses that appeared in our last sitting, Mr. Litswalo could also appear and just field questions from members. But of course, if he wishes to provide a sworn statement, he's at liberty to do that. But the committee would not be in a position to offer him paid legal assistance in any way, or secretarial support. To the extent that we can assist, we will assist. We have provided all the documentation, as you've indicated. And in fact, when we sent the very first invitation letter, we sent that at a time when we were very busy with the RAF trying to compile our record. And we had given a date of 20th September to let us know if there are any documents you feel that we should ask for, so that we could try and facilitate that. Of course, there was no response at that time, but yet we continue to provide whatever documentation we can. So I'm not exactly clear on what Mr. Letswalo is indicating in the letter when he says he wants legal assistance. We can surely offer assistance to help him draft his statement if he's willing to accept that assistance from us as legal services, but we won't be able to offer legal assistance in terms of representation if that is what he is implying. Thank you, Chair.
Thank you. Thanks, Ms. Ibrahim. Mr. Madlala? Sorry, let me ask, Honorable Beasley, I had seen your hand and then it disappeared. Let me just make sure that you no longer wish to speak, or you put it down because I had recognized your hand already.
No, I put it down, Chair, but I was just going to support the suggestions that you made, but you might still be coming to that, so that's why I lowered my hand.
Okay, all right, thank you. Yeah, Honorable Madlala?
Thank you, Chair. I think your proposal, I want to support your proposal on the dates of appearance, that we give Mr. Letswalo a time frame within which the inquiry is to be concluded, and advise him to give us dates within that time frame. And I think I just wanted to add a comment to say that we need to try, in the spirit of the letter that we sent, to make Mr. Letswalo understand that he's not just appearing before SCOPE. I know that he knows it, but there are leveled issues before this platform which are of public interest. So he needs to give the public his version of the story. This is not a legal matter in court, which is being litigated. So in terms of legal representation and all of that, and he has a right to answer what he thinks he can and what he thinks he cannot. He will just state that. But our spirit within which we engage with him should not premise a view that, for example, which was indicated earlier, the evidence presented by SIU that they have not been able to get hold of him for the past 6 months, and it's been delaying the processes and all of that. Because he may come and present a different version of events. So whichever witness and whichever information we have not synthesized and processed it, because we can't process it without having heard all sides of the story. So we can't take one version as the gospel truth, whilst we know that it's information under oath, but what we need to give everyone a leveled ground to say, come and express yourself on these matters. We will then process all information and make recommendations at the end. Because if we start by saying, we already think that he's going to just delay us, he's just rebellious and he's not willing to cooperate. And if we send that spirit, that is the spirit within which we're going to get responses. And I think it's in the interest not of our own egos or our own purposes as members of parliament, but of the public to be able to understand as well, besides the fact that we want to make some recommendations and have a clear throughput and outcome of this process. But it is in the interest of also, everyone involved and everyone who's following up the matter to understand what exactly was happening, so that we draw to logical and objective conclusions at the end. So I just wanted to make that minor comment towards my last comment on this matter, that the spirit within which we communicate, we try and cleanse ourselves of any other previous subjective matters we have in our minds, or knowledge, for example, because this is a new process and we must treat it as such, even though we may have had experiences with any witness or any candidate that is going to be presenting themselves before us, but we treat this with as a complete new process with the necessary objectivity. Thank you.
Thank you, Honorable Madlala, for that guidance. Much appreciated. Honorable Skosana, your final word?
Yeah, no, thank you very much. No, I agree with the other members. One, in terms of allowing him, though you did previously, but I think let's allow him once more time. If he says he's not sure about the 4th and the 5th, let's allow him to suggest other dates, as long as those dates they fall within the set time frame. But if there are difficulties, I think we should be prepared maybe to accommodate him, even if it means we may have to extend the time frame of the inquiry maybe by 2 weeks or 3 weeks, but it can't be beyond a month. I think we can be accommodative and reasonable to say we can maybe extend the time frame maybe by 2 weeks or 3 weeks or up to a month, but it can't go beyond a month. We can't extend it beyond a month as a way of trying to accommodate him. But I'm just saying one more time, let's accommodate him. Allow him, if he says he's not compatible with the 4th and the 5th, he's still consulting legally, like we are saying, allow him space to do that, but let him suggest a definite date, 2 definite dates that he will be able to come. If those dates falls outside, we can maybe extend by 2 weeks, 3 weeks, up to a month, but not beyond that. And secondly, on the issue of legal representation, I think I agree with Ms. Ibrahim that it will be unfair to other witnesses if we are going to, as Parliament, arrange legal representation for Mr. Litsualo, whereas we are unable to do it for others. So it is his responsibility to do that, but he is not compelled to do it. I think he can write a statement himself, or he can come without, he can just come with a presentation, not a sworn statement like other witness did. So it's not something that is compulsory, that definitely he is supposed to bring a sworn statement, which may require a legal assistance. Thank you very much, Chair.
Thank you very much, honorable members. We really appreciate the guidance. I also think if in the event, and this is if we have to discuss a subpoena, in other words, there is no agreement between the Secretariat and Mr. Litsualo on his date of appearance, if to the extent that he has proposed a new date, a different date, then the committee would need to discuss that as part of its decision-making process in terms of whether there is a subpoena or not. I think we'll get another opportunity, but thank you very much, honorable members. The final thing I'd like to ask the members to give views on, we have a whistleblower who has provided extensive information to the committee. It is a former employee of the Road Accident Fund. And they've provided this information in writing. They've also provided this, they've also been speaking to the committee. They are worried about potential harm, and they are asking, and the witness is asking for a virtual, for their real name not to be used, even though they would disclose it to the Parliament team. And they say they've been assisting the SIU, and that SIU has confirmed his identity, and that we are free to confirm also with the SIU that the person that Parliament is confirming is the same person. They don't mind speaking with their own voice, but they would like their face to not be shown. And that would mean that we conduct a virtual hearing with the person. They would speak, they would answer, they would submit a statement and so on. But 2 things: 1, don't reveal my real name. Secondly, don't show my face. But you can certify that I am who I am, I say I am, and that the matters I am speaking about that I've submitted to the committee are matters within my personal knowledge in terms of my role at the Road Accident Fund. So I just wanted to, because we need to respond to this person and say, whether they can appear under these conditions or not. Now, what the committee has got an option to do is to decide also what weight to allocate to that information under the circumstances. But I'm placing this before the committee members because we need to say yes or no to the person. Honorable Mende.
Chair. We are now being presented with the most difficult thing, and we all know the answer to this. Once a person is not comfortable in being known, it is what it is. They're not comfortable in being known. So what I think we have in our disposal is to ask Parliament to make this in camera. Because even if we say it's going to be virtual, we have seen whistleblowers in South Africa disappear. Now we must have it in virtual people, and then the poor person is already having to make her name known to Parliament. We don't know how many people know her name in Parliament already. We don't know who to trust and who not to trust. This is South Africa, where people disappear and nothing happens. They die, they are found dead, they die in hail of bullets. So if that's the case, that person has already said to us, I'm scared. So we can't be part and parcel of exposing them, even if they are going to be virtual and have their voice disrupted, all those whatever that they do. But this one means it must be done in camera. It can't be done for other people to listen, because obviously, if I had a transaction that I dealt with you, even if your voice has been corrupted or you are hidden and whatever, I know you're the only person who knows this type of information. And that's very risky. Thank you, Chair.
Thank you, Honorable Mende, for that input. Can I get the input of other members? Honorable Beasley, and then Honorable Mandela.
Yeah, thank you, Chair. If the witness was comfortable what you were suggesting, then I think, ultimately it's a witness's choice. So if they were comfortable with what you're suggesting, I would support that. Thank you, Chair.
All right, thank you. So let me also make clear, colleagues, and to you, Honorable Mende, that the person has said that we wouldn't need to corrupt their voice. So he does know that those who know him would know that it's him, but he doesn't want wide distribution of what he looks like, given the issues he's going to traverse. It's his choice, right? I share your anxiety. And I think we always have to balance the need for public participation and viewing, as well as the wishes of the witness. So what I have shared with the committee members is the wishes of the witness. I appreciate the caution, Honorable Member. I actually share it too. But I'm placing to the committee what the witness has said. And of course, we are free to take our own decision if we feel that the thing must be in camera, and we'll ask for advice from the Parliament legal team as to that process. Honorable Kubeka.
Thank you, Chair, and greetings to the House. Chair, I do share Honorable Mente's suggestions and opinions on this one. This is a very sensitive issue. Again, the issue of whistleblowers in South Africa, we know what happens to them. So as long as we can take utmost precaution regarding the issue and making sure that we do our best as Parliament to protect the witness. If they are saying let's go on online, I would suggest let's do that, Chair. Thank you.
Thank you. Honorable Isaac. So let me take the honorable members in one after the other. Honorable Isaac, you first. Honorable Nondenja, you next, and then Honorable Skosan.
Chair, am I audible? Chairperson, am I audible?
Yes,
you are.
Very audible, okay. Honorable Isaac.
Oh, great. Thank you. Chairperson, yeah, I don't think we should be deliberating any further on this matter. I mean, you have outlined very clearly and explicitly that the witness is happy to go on virtual as long as the individual's face is not displayed. So I don't see what is the problem and why we should be technical in debating an issue. The witness is happy. We're, I think, conducive to accommodating the witness. So yes, we'll go virtual, and we don't have to display the individual's face, and we can interrogate and listen to the presentation of the witness. It's senseless us just debating to and fro. Thank you, Chair.
Thank you, Honorable Isaac. Honorable Nondenja.
Thank you, Chair. Listen, I think Honorable Isaac has mostly covered me. We have to protect the whistleblowers, otherwise we will have nothing in future. So the fact that the whistleblower has indicated how she or he would like to give us the information, to me is one thing that we have to adhere to and respect. Thank you, Chair.
Thank you, Honorable Nondenja. Honorable Skosana.
No, thanks, Chair. Yeah, no, I'm agreeing with the other members that if the witness elect to use that kind of a procedure in order for him or her to appear before the committee, let's allow him or her to do so. Because I believe that he or she strongly believe that she's got information that she or he can share with the committee that can assist the committee. But I think we need to also be circumspect on the side of Parliament that whoever will be handling the process of having the identity of the witness should make sure that that information doesn't leak, so that other people end up knowing who the person is. So on our side as Parliament, we need to make sure that we become very circumspect in the handling of that particular information. But we can't deny a witness an opportunity to appear before the committee because we are worried about challenges of whistleblowers becoming victims and stuff like that. Well, I understand the concern that is raised by Honorable Mente. However, it is the initiative of the whistleblower to do that. It's not like it is us who approach him or her to say, come and appear visually. It is him or her who's initiated that. So I think we should allow that, but on our side, making sure that we become circumspect in handling the process. Thanks, Chief.
No, thanks, Honorable Skosana. We really have taken care to make sure that the witness, these are conditions the witness is comfortable with. And like I said, what I'm placing on the table is a level of protection that the witness has defined and said, I'm comfortable. I want to speak in my own voice, but don't tell people who I am or show my face, but you can certify that I am this person who held this role at the Road Accident Fund. These matters were within my personal knowledge. So, and we can ask for other independent verification, that is from the Road Accident Fund, from the SIU, and from all other records, so that we are sure that we're not talking to a fake person. Honorable Mente, I'm not sure if that's your old hand or it's a new hand.
Legacy, Chair. Sure.
Thank you very much. Okay, so we will go back to the witness and say the committee agrees that with the level of protection that the witness has defined. I don't think it's unreasonable, to be honest with you. Then the public can also hear what we've heard as a committee, but we do what is comfortable for the witness. So thank you very much, honorable members. There are no other issues. Like I said, once the letter has been written, we will share it with the members so that they know what letter has been dispatched to Mr. Litswalo. and then of course we'll come back to the witness in accordance with the decision of the committee. Ms. Ibrahim, I just want to be sure that we all done in terms of the issues that were important.
Yes, Chair. Thank you.
Thank you very much, honorable members. Do have a good weekend. Please watch out for your emails. We'll also write on the group, because we are going to send documents for next week. Some of them have already been sent, but we're going to send more so that at your own time, you can look at them. Thank you very much.
Thank you very much. Yeah.
Thank you.
Bye-bye.
Thank you, Chair. Good weekend, everybody.
Thank you.
Bye, Billy.